Interested in hearing his remarks today.
Thank you, Professor Turley, and thank you all for coming out this afternoon, and also to ACS for putting on this, what I hope will be a great and informative event. I want to try and do three things during my 5 to 7 minutes. First, I just want to go over what I think some of the principles that should animate any state secrets reform legislation are, and then I'll dive right into the two bills that are currently pending in the Congress, one before the Senate and one before the House, and talk about the large similarities between those two bills, and then finally at the end mention what are a few minor differences, perhaps more in tactics than in overall strategy and effect between those two bills. So to begin with what I think the sort of core principles that should be part of any state secrets legislation, and this will largely build out of and echo what the prior speakers have said. I think the first thing is it should actually serve the purpose of the state secrets privilege, which is to protect national security and to protect secret information. So any legislation should preserve this common law idea that there is a privilege when state secrets are in play, and that if evidence, if the disclosure of evidence really would be a harm to our national security or our foreign relations, that evidence should not be disclosed. A second thing that legislation should do is to prevent abuse of the privilege, and we've heard going all the way back to Reynolds about how the government, by having control over this privilege, can use it to shield its own unfortunate or illegal or negligent conduct from scrutiny. And the problem with the government doing that is, one, it covers up illegality or negligence, and also it starts to undermine the privilege itself, and there's an extent to which if the privilege keeps getting overused and abused, the country as a whole, and judges in particular, I think will lose confidence in the credibility of the government and in the correctness of there to be a privilege in the first place. So I think any legislation should make sure there's no abuse. And finally, legislation should try and help courts do their jobs and litigants obtain justice. The reason that Congress has set up federal courts and the Constitution in Articles 1 and Article 3 gives Congress the power to give jurisdiction, at least to the lower federal courts, is so that courts can resolve the cases and the controversies that are before them. And when the government uses the state secrets privilege, as it has in the cases that have been talked about, to keep judges from resolving cases, there's a problem, and we start to sort of lose the idea that the U.S. is a country of laws and a country where people can obtain justice in courts. So I think that both the House and the Senate bills are remarkably effective in doing all three of these things, and let me just sort of quickly go through the really overwhelming similarities in how they do that. First, the two bills define what the state secrets privilege is in essentially the same way, which is that some